Good morning, all. My name is Richard Sabas. I'm a BSBA student majoring in Management Information System. Today, in this video presentation, I will be tackling the labor case of Reyman Mensola petitioner versus New City Builder Incorporated and engineer Ernel Pajardo respondents with GR number 207-61613, and I will give my own observation and analysis, reaction, and conclusion. Um, this video presentation is created to fulfill my requirements for the project course for the labor relations and negotiation course project. In this presentation, I will examine the following and provide you with my own opinion. First is the facts of the case. Second is the complaint filed by Mensola. Third is the ruling of the labor arbiter. Fourth is the ruling of NLRC. Fifth is I will reiterate the issues which is already covered in the case. And lastly, the ruling of the court. The first part that I will be presenting in this video are the facts of the subject case, and I will go over them one by one. I will be focusing only on 5 facts that I have identified on this case. First is the court recognizes the right of the employer, New City Builder Incorporated, to hire project employees. In the first paragraph in the labor case number GR number 207-61613, it is clearly mentioned that the New City Builders were recognized by the court to hire project employees. Furthermore, the New City Builders are organized under the law of the Philippines, engaged in construction business. As such, construction industry have two classification of employees as per ILO, Department Order Number Section 2.1, wherein Section 2.1 classifies two different kind of employees in the construction industry, and it clearly defines the project employee as stated. In Section 2.1, classification of employees, the employees in the construction industry are generally categorized as a project employee, a non-project employee. Project employee are those employed in connection with a particular construction of project or phase thereof, and whose employment is coterminous with each project or phase of the project to which they are assigned. I have cited this reference since this is connected to the second fact that I will be discussing, which is the hiring of Mensola. The second fact of this case is that Reyman Mensola was clearly hired by New City Builder Incorporated as a project employee. As mentioned in the antecedents, Mensola was hired on December 16 as a laborer for the structural phase of Abida Tower project, and was clearly stated in the contract that the employment duration will last until the completion of the project of the structural phase. Meaning to say, he was only hired for that specific project based considered as a project, meaning to say he was only hired for that specific duration which considered as a project base as per the Labor Code employee classification, and as well as the ILO Department Order 19 Section 2.1 classification of employees in construction industries, as I mentioned earlier. Furthermore, after the completion of the structural phase, Mensola was given and received the notice of termination, which is the third fact that I will be discussing on this case. The third fact is, after the completion of the project phase, a notice of termination was issued to Mensola, and he received it on August 24, 2009 as stated. Subsequently, on August 24, 2009, the structural phase of Babida 3 was completed. Thus, Mensola received a notice of termination, which stated that his employment shall be effectively terminated at the end of the working hours at 5 p.m. on even day. Thus, the employment of Mensola is not continuous. His first employment as a laborer was terminated upon the completion of the structural phase. He was just rehired for another project based on the following day with a different job as a mason as stated. On August 25, 2009, New City rehired Mensola as a mason for the architectural phase of Abida 3, which is once again considered as a project-based employment. In this case, in the employment of Mensola is for two different project bases with a different job requirement. Therefore, it should not be considered as one or continuous employment and rather should be treated as separate employment. The fourth fact is no appointment letter for rehiring Mensola as a mason. Upon the review of the new city in December 2009, it was found out that Mensola has no appointment letter as a mason for the architectural base as stated. Meanwhile, sometime in December 2009, upon reviewing Mensola's employment record, New City noticed that Mensola had no appointment paper as a mason for the architectural base. Consequently, New City instructed Mensola to update his employment record. However, the latter ignored New City's instruction and continued to work without an appointment paper. On this note, I can see lapses in both parties, the employee and the employer. As employee, we should exercise our rights to ask for legal documents pertaining to any work we render. On the case of Bensola, he did not ask for the l- latter contract as a mason, and bear in mind that he already received a termination of employment for his previous contract. It is only practical to secure a legal contract as employee before rendering any services. Mensula make it only worse when he ignored the instruction of the company and continue working without any documentation. And as for the employer, HR should be proactive to make sure that all hiring process and documentation are in place to avoid any grievances. And the last fact is Mensula was not illegally dismissed. Instead, he never reported back to work in his own volition. This clearly shows that New City did not illegally dismiss Mensula or did not do anything to hinder Mensula in reporting back to work. New City is only complying on the documentation for rehiring Mensula because Mensula because his re-employment is based only in a verbal hiring. As mentioned in the antecedents, on January 20, 2010, Mensola was again summoned to the office in New City to sign his appointment paper, and Mensola adamantly refused to comply with the directive. He stormed out to the office and never reported back to work. Next, we will look at the complaint filed by Mensola. He filed against New City Builders Incorporated that he is illegally dismissed, underpayment of salary, non-payment of 13-month pay, separation pay, refund of cash band, and he claimed that he is a regular employee and he is constructively dismissed. Based on the Based on the complaint filed by Mensola, the Liberal Arbiter came into decision in which I agree based on the facts that I stated in the first part of this presentation. On October 8, 2010, the Labor Arbiter rendered a decision dismissing the complaint for illegal dismissal. The LA found that Mensola was a project employee who was hired for a specific project by New City. The fact that Mensola worked for more than 1 year did not convert his employment status to regular. The LA stressed that the second paragraph of Article 280, which refers to the regularization of an employee who renders service for more than 1 year, pertains to casual employees. Furthermore, let us remember that Minsola was hired into a different project base with a different job requirement, and that his first employment was actually terminated upon the completion of the project. And he was rehired the following day, which is for a different base, and this should not be considered as continuous. In the case of dismissing other monetary claims, LA should consider that Minsula was in fact underpayment of salary. Minsula was given a daily wage of 260 pesos as shown by his employment contract dated December 16, 2008. At the time of hiring, the minimum wage is already 382 pesos as per the wage order number NCR 15 effective August 28, 2008 to June 30, 2010. As for the ruling of NLRC, to sum it up, my opinion is agree to disagree. First, I disagree on the decision of the NLRC that Mensola was a regular employee and was constructively dismissed when he was made to sign a project employment contract. Once again, Mensola was hired for a specific duration of the project and base and his first employment was actually terminated, and therefore his employment in New City Build is not continuous, and he was hired separately in a two different position. As for the monetary claims, I agree on the decision of an LRC. It is only imperative to give the monetary differential to Mensula and other incentive as long as the services is rendered. Similarly, I agree to the ruling of the CA, the same as ruling of LA. Next are the issues. We'll go over these issues based on the ruling of the court. First is whether or not Mensula was a project employee. Second is whether or not Mensula was constructively dismissed by New City. And third is whether or not Mensula is entitled to his monetary claims. First is whether Mensula was a project employee. As per ruling of the court, Mensula was clearly a project employee based on the evidences, which is the hiring contract that is clearly stated the duration of the employment, and also Mensula was adequately informed that the nature of his job as well as the duration. Next is whether Mensula was constructively dismissed by New City. In this case, the court was not persuaded on his claim that he is constructively dismissed, on which I also agree. As I mentioned earlier on the facts of this case, it was Mensula who did not report to work on his own volition. New City did not stop him or hindered him not to report to work. Therefore, his claims is lack of merit. Lastly is whether or not Mensula is entitled to his monetary claims. Mensola is entitled to his monetary claims. I do agree, as I mentioned, as long as the services are rendered, all incentives must be given to Mensola. As for my conclusion on this case, based on the evidences presented, the monetary claims of Mensola should be given to him as per his rendered services, and the rest of his claims will be dismissed due to lack of evidences and no merit at all. My conclusion is solely based on what is presented and available evidences and resources in this case. This is the end of my presentation. Thank you all.